Yo, what up, losers? I don't know who else had fun last night, but I did. I have special announcements for the end of the stream today, but I'm going to wait till the end because I decided that. So if you want to know what's going on at the end of the week this week, you have to wait. Patience. This is training. Oh, so I'm excited. Today we're on, last time on Dragon Ball Z, court orders were held up, so the partial judgment by default was upheld to still be in effect. Kyle resubmitted his motion to set aside. They gave some affidavits to support their claims, as the first time this was submitted, there was no corresponding evidence. All it was Kyle saying that I did, but I didn't live there. And so once he finally got a lawyer after he lied about having an attorney, the lawyer had affidavits by Kyle as well as Kyle's mother to say that, yes, I did sign for this, and no, Kyle was not living here. There was also some of the stuff that we saw before that was submitted that was the signature by Benjamin Potts about the lease agreement, etc., etc. And so today, we're going to check out the response/opposition brief, which is essentially Steve's lawyer responding to that brief in support. So we are on 32. If anybody is following along, I will put the link in the description this time. Putting the link in the description I don't find isn't really that helpful, so it's usually just best to search it yourself. So if you just Google North Carolina Business Court, it will come up as public access, and you can just that link. But hopefully this is helpful for anybody who A, doesn't have time to read it themselves, and B, doesn't like reading, or C, is too busy to do. Like, listen, I understand some people just do not have time to sit down and read through all this. I don't have time to sit down and read through all this, but I'm doing it anyway. So people can kind of listen to this in their cars on their way to work and stuff, so you guys can know what's, or hell, if your job is driving. I don't know your life. I'm just here to try to help. Quite frankly, all of Steve's trolls and all the people who hate Steve should be thanking me for reading this for them, since we all know most of them can't read. But, alright. let's jump, let's pull a Philip DeFranco and jump right into it, I guess. 32, plaintiff's response in opposition to defendant's amended motion to set aside default judgment. Ooh, baby! North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division 19 CVS 8163. Response in opposition to defendant's amended motion to set aside default judgment. Also, 10 points in the chat to anybody who could guess what my scheming from last night might be leading to. I'll announce it at the end. Plaintiff Stephen McCrae, through his underpaid counsel, submits this response in opposition to defendant's amended motion to set aside default judgment. Objection and a motion to strike. As an initial matter, plaintiff objects to defendant's amended motion and brief as being procedurally improper. The business court rules do not contemplate amended motions. Moreover, defendant's amended motion and brief in support do not state any new grounds for the request relief that would require an amendment. Rather, defendant's amended motion is more accurately described as a late reply brief in support of his original motion. As such, the amended motion and brief should be disregarded. At a minimum, plaintiff requests that no further reply brief be permitted and that a hearing can be held at the court's earliest convenience. Matter before the court. The matter before the court remains largely as it was when plaintiff filed his initial response brief, ECF number 21, which is incorporated herein by reference. To the extent there was any question, defendant's brief and affidavit confirmed the relative facts of service. None of the following are disputed. The list of the following. The summons and complaint were served by certified mail on August 30th, 2019. Kyle Curtis, affidavit ECF number 31.1 at paragraph 6. Suzanne Curtis, affidavit ECF number 31.2, paragraph 3 to 4. The certified mail receipt was signed by defendant's mother, Suzanne Curtis. Defendant had lived at the address with his mother at least through July 2019. Kyle Curtis, affidavit ECF number 31.1 at paragraph 2. Suzanne Curtis, affidavit ECF number 31.2 at paragraph 4. Defendant does not deny that he actually received the summons and complaint. Kyle Curtis, affidavit ECF number 31.1, and Suzanne Curtis, affidavit number 31.2. Stephen McRae, affidavit ECF number 22, paragraph 7. So essentially, what Steve's lawyer is saying is that Kyle's paperwork doesn't actually say anything against the service, and if anything, bolsters the initial service that did happen. I appreciate that face, that drawing comes after the Trigglypuff. I appreciate that. That's clean. I like that. I think that's the face a lot of people were making when they read Kyle's stuff also. Legal standards. The legal standard for service by certified mail pursuant of Rule 4J1C, a challenging that service is established. I'm pretty sure that's a 1 and not an L. Maybe I should copy paste it into something and see what it comes up as. If I put it in here, and then I put an L beside it, or a capital L. Hell yeah, that is a 1. I was right. Okay, fantastic. 4J1C, and challenging that service is established in Granville Med Court v. Tipton. 160 NC App 484 568 SE2D 791 2003. The plaintiff must file an affidavit of service 1, stating that a copy of the summons and complaint were sent by certified mail, return receipt requested 2, stating that the copy of the summons and complaint were actually received as evidenced by the registry receipt, and 3, attaching a genuine copy of the receipt ID at 490. The affidavit, quote, raises a presumption that the person who received the mail, ellipses, and signed the receipt as an agent of the addressee and authorized by appointment or by law to be served or accept service of process, end quote, ID quoting Rule 4J2, see also Fender versus Deaton 130, NC App 657, 662 to 63, 503, SE2D 707, 1998. Whew. Center? Sorry, I said court. Yeah, sorry, my mistake. Thank you, AG2. It's Granville Medical Center, not court. The presumption arises... Did I skip something? No. The presumption arises regardless of whether the defendant signed the return service. Quote, the presumption arises upon proof of delivery regardless of the identity of the signer. ID at 491. To rebut the presumption, the defendant, quote, must present evidence that service of process failed to accomplish its goal of providing defendant with notice of the suit, rather than simply questioning the identity, role, or authority of the person who signed for delivery of summons, end quote, ID at 493. Argument. A. Defendant has failed to rebut the presumption of service. Defendant makes no attempt and does not contest that the presumption of service is proper. Rather, defendant attempts to rebut the presumption based solely on the fact that he claims he no longer lived with his mother at the time service was made. That contention, even if true, is insufficient to rebut the presumption of proper service. So, spoiler alert, all the stuff that Kyle faked to pretend he was living somewhere else wouldn't have even mattered anyway, so he just basically unnecessarily dug himself into a hole that didn't matter. First, as stated in Granville, defendant must show that service failed to accomplish its goal in providing him with notice of the suit. ID. Defendant never claimed that he did not receive notice. None of the affidavits he has submitted claim that he did not receive notice. As in Granville, the allegations that he filed to receive the summons or notice of the suit is conspicuously absent. So basically, if you find out there's a lawsuit going on that you weren't served for, it's your responsibility to go to the court and ask for that information. So Kyle, knowing he was being sued, having not received service, assuming that he actually did not receive any paperwork, knew he was getting sued and did nothing to reach out to the court or anyone to find out, to get the information that he would need to actually address it. So conspicuously absent is what that means there. ID 493 to 94. Moreover, defendant has acknowledged that he had notice in various internet forms, including those identified in plaintiff's initial affidavit, McRae Affidavit ECF number 22 at paragraph 7. Second, it is insufficient to simply argue that defendant's mother was not authorized to accept service for him. Defendant apparently contends that, because he no longer lived with her, his mother was not authorized to accept service. But as stated in Granville, it is insufficient to rebut the presumption of proper service simply by, quote, questioning the identity, role, or authority of the person who signed for delivery of the summons, end quote. ID at 493. Conspicuously absent from defendant's affidavit is any allegation that defendant's mother was not authorized to sign for certified mail addressed to the defendant. Third, assuming it is true that defendant did not live with his mother on August 30th, 2019 when service was made, that is not enough to rebut the presumption. Defendant apparently contends that service by certified mail must be made at an address where he pays rent, receives mail, or has reported to an employer to be his residence. Kyle Curtis, Affidavit ECF number 31.1, paragraph 3 to 4. Plaintiff cites no case law or statute supporting this alleged requirement. And even assuming defendant's affidavit is true and that he can receive mail at the Charlotte address, that does not preclude him from being served elsewhere. In a different Rule 4 context, courts have found that a defendant may have more than one location where he or she can be served. Quote, it is unrealistic to interpret Rule 4 so that the person to be served only has one dwelling house or usual place of abode at which process may be left, end quote. In Re George 825 SE 2D 1927 NC App 2019, quoting Van Buren versus Glasgow 27 North Carolina App 15217 SE D2D. I've read that so many times I've got it all backwards now. 579 1975. Hey. AT2 said, it'd be one thing if service delivered to a family member was given to a family member that the defendant does not have contact with. Maybe he should have tried that argument. I don't think that would have, I don't know. I don't think there is any argument that he really could have gone with here. If he wanted to go with his argument, he still probably should have brought that up first instead of not complying. You can hear Puck being a Borky boy outside. There's an adorable little, I don't know what kind of, like, bulldog or little Frenchie. I don't know what kind of dog he is. He's like this big, and he's a stout little boy, and his name is Louie, and he's adorable. But he likes to bother Puck, which is also hilarious because Puck is gigantic. I love everything about it. Here, because defendant had previously lived with his mother and had apparently done nothing to change his address with the post office, he could still receive mail at his mother's house. She was therefore authorized to accept service of process. If defendant no longer wanted to receive mail at his mother's house, he could have simply changed his address with the post office, which would in turn have provided notice to plaintiffs so that service could be sent to the forwarding address. Yes, if you move, you're responsible to make sure you get your mail. Shocking, I know. Adulting is hard. Or Miss Curtis could have refused to sign for the certified mail when it arrived, which also would also have served to notify plaintiff. Instead, defendant did nothing. Yeah, basically, so if Kyle's mom had refused to take service, to be like, no, that's not my business, I can't sign for that, it would have come back as not can't be received or can't be delivered or whatever, and then that would have notified Steve's lawyer that it needed to be sent to another place. Right. Instead, defendant did nothing, boasting about doing nothing publicly on YouTube. He's still doing that. And filed nothing until February 6th, 2020. That's, how many months later is that? So he served in August, September, October, November, December, January. 6 months. 6 months! 5 months after he had received the summons and complaint served at his mother's house, mother's residence. See, I'm counting that as 6. Hold on. August, September, October, November, December, February. Okay, yeah. I counted August, and it was the end of August. I shouldn't have counted August. My mistake. So it was nearly a total of 5 months. 5 months, if you count like that was February 6th, and it was August 30th. But if you only count the months, yeah, 5. And don't forget updating AT2 says, and don't forget updating the address on your license ID. A simple mailed submission to the DMV RMV does that too. In Canada, you can change your address online for like your health card. There's also, like, if you voted, you also have to, update your address with the voting registry. Case law addressing service by certified mail on an individual defendant that provides actual notice to the defendant clearly favors holding that service was proper. Most of the cases cited by defendant concern service in manners other that by certified mail pursuant to Rule 4J1C. Mess at that time. Defendant cites no case where an individual defendant was served by certified mail. The presumption of service arose under Rule 4J2, and the defendant was able to rebut the presumption because he or she no longer lived at this service address. By contrast, North Carolina courts have held service to be proper when the defendant was served by certified mail. The presumption... This is like mail-in ballots kind of crazy. It can't be. You can't use my regular snail mail. It could be fraudulent. I really wish I could do a Kermit the Frog voice. Oh, hello, I'm Kermit the Frog. Yeah, my Kermit the Frog's not very good. I should practice that. Oh, where was I? Certified mail. The presumption of service is established by the filing of an affidavit of service, and the defendant had actual knowledge of the pending lawsuit. For example, in the Granville case discussed extensively above, the defendant was served by certified mail, the affidavit of service was filed, and the court found that the presumption of service was raised. 160 NC App at 492. The defendant attempted to rebut service by saying that 1. He did not sign the receipt personally, 2. The receipt was signed by someone with the same name, Hedgepeth, and 3. Defendant had never employed anyone named Hedgepeth, agent, officer, employee, or principal, ID at 493. The court found that this did not matter because the crucial issue was, quote, whether or not defendant in fact received the summons, end quote. ID at 493-94. Just as in this case, the defendant did not dispute that he received actual notice, ID. Therefore, the defendant failed to rebut the presumption of service and the motion was denied. Similarly, in Fender v. Denton, the defendant was served by certified mail at his law firm and the return receipt was signed by his wife, who was an employee at the law firm. 130 North Carolina App at 658. Defendant did not deny that he received the summons and complaint, but attempted to rebut the presumption of service by saying that his wife was not authorized to accept service. ID at 63. The court found that the defendant had failed to rebut the presumption of proper service. In Steffi v. Mazza Construction Group, which involved service under Rule 4J5A, The court found that service on the city of Burlington was proper even though the certified mail receipt had not been signed for by the mayor, city manager, or clerk. 113 NC App 538, 539 to 40, 439 SE2D 241, 1994. Rather, because the affidavit of service raised the presumption pursuant to Rule 4J2 that the signer was authorized to accept service, and because the city actually received notice service was proper, ID at 540. In Hawk versus I don't know, whatever, somebody, which involved service in a foreign country, Rule 4J3, the defendant was served by certified mail addressed to the defendant, care of his mother, and delivered to his brother's address in South Africa. 118 North Carolina App 630, 631, 456, SE2D 858, 1995. Listen, it doesn't even matter if you're out of country, god damn it. The court, noting that there was no doubt that the defendant had actual knowledge of the case, held that the service was proper, ID at 635. The clear weight of the case law concerning service by certified mail on an individual when the presumption of service arises and the service achieves the purpose of Rule 4 of providing actual notice favors the conclusion that service on defendant was proper. Defendant has treated and continues to treat this lawsuit as a children's game. Yes, if anybody hasn't seen what we've gotten to up until now, I do recommend going and watching this as kind of like a whole thing, but definitely put it on faster speed. I also definitely recommend looking at the Prelude prequel thing that I did, because I just think that one was important. And so that might be my own personal bias, but I think that was important. So go and check that out. Defendant has treated and continues to treat this lawsuit as a children's game. It is indisputable that defendant had notice of the lawsuit and simply chose not to respond. He was receiving correspondence about this matter, at least by email, before the case was even filed and before he was served. ECF number 21, Exhibits B and C. The summons and complaint were served and signed for by defendant's mother, and defendant does not dispute that he received actual notice. ECF NOS 31.1 and 31.2. Defendant publicly acknowledged on YouTube and Discord that he had been served and that he failed to respond by the deadline. McCrae Affidavit ECF number 22, paragraph 7. Papers that I was served. Papers that I was served. Papers that I was served. As noted in plaintiff's original brief, the court need not put itself, quote, in the position of failing to recognize what is apparent to everyone else. Granville 160 NC App at 493. Internal quotation omitted. Here it is apparent that defendant knew about the lawsuit, ignored his obligations, and flaunted his default. Moreover, defendant has used this matter and the delays brought about by the pandemic to play games. Defendant has not complied with the judgment as he was obligated to do, even with his Rule 60B motion pending, because his motion did not affect the finality of the judgment or suspend its operations. The court reminded defendant of his obligation in its order. It entered April 13th, 2020, ECF number 26. Regarding the court's order, defendant continued his refusal to comply and took it a step further by using his continued control of the non-sequitur assets to falsely accuse plaintiff of copyright infringement. McCrae Second Support Affidavit ECF number 27. While that matter is ripe for determination at another time, it demonstrates defendant's attitude towards these proceedings. Quote, a lawsuit is not a children's game, but a serious effort on the part of adult human beings to administer justice, end quote. Granville 160 North Carolina App at 493. Internal quotation omitted. Finally, setting aside the judgment would reward defendant for his behavior while severely prejudicing plaintiff. The provisions of Rule 4 allowing service by certified mail and the presumption of service are designed to give plaintiff the ability to initiate legal matters. And while it may be true that court favored depositions on the merits, it is also true that, quote, statutory provisions designed to protect plaintiff from defendants who do not give reasonable attention to important business affairs such as lawsuits cannot be ignored, end quote. Estate of Teal, ex rel. Nadio versus Darby, 129 NC App 604, 607, 500 SE 2D 759, 1998. Compliance with Rule 4 protects plaintiff from defendant's willful delay and a default which cannot be ignored. Oh, SUP is supplemental. Oh, sorry, thank you, yes. Conclusion. Defendant had... Yeah, so when I said Steve's... I said... what did I say? I said support. Second support. It's supplemental. My mistake. Conclusion. Defendant has failed to rebut the presumption of service, therefore defendant's motion to set aside the judgment should be denied. Respectfully submitted this 11th day of August 2020. This is nearly a year later. Remember, service was on August 30th, 2019. This is the 11th day of August in 2020. Certified compliance does not exceed 7,500 words. Thank you, court. Certificate of service going to Kyle's lawyer. Same date. And that's number 9. So, reply brief. So this is Kyle's lawyer's response. Whip. I don't like that it jumps to the top like that every time. Here we go. Number 33. Reply brief and an affidavit. Oh, I should get Puck. One moment. I'll be right back. I'll get him back in here because he is currently in the outside land being a borky boy. One moment. I have returned. Puck is here. He is under the desk. And this is my tomato plant, which was outside with the dog. And it is getting blown over by the wind. Poor little tomato plant. Alright. Shall we continue? So this is Kyle's lawyer's response. State of North Carolina, Guilford County, Stephen McRae, plaintiff versus Kyle Russell Curtis, defendant. In the General Court of Justice, Superior Court Division, 19 CVS 8163, reply brief in support of Kyle Curtis's amended motion to set aside entry default judgment and partial default judgment. Hey, is it already dying? No, it's okay. See, it's fine. It's got some, like, solid root structure. It needs to be replanted in, like, a bigger pot, but I don't have one. There's a pot shortage where I live. It smells really good, though. I really like this plant. I'm happy with it. I grew it off of just some cherry, like, it's a Roma tomato plant. I grew it off of some tomatoes. It's doing pretty good. But it needs to be replanted into a bigger pot because right now there's just not enough going on here. Maybe I can put more dirt in there, that might help it out, but... A pot shortage, is that because it was recently 420? Maybe. Alright. Pursuant to Rule 7.7 of the North Carolina Business Court Rules, defendant Kyle Russell Curtis submits this reply brief in support of his motion to set aside and the entry of default judgment and partial judgment entered against him in this case. Although now this plant is right beside my mug of tea, so you guys keep an eye out for when I try and grab this to drink out of it, alright? Introduction. Mr. McRae's response confirms the key point in Mr. Curtis's amended motion to set aside, that Mr. Curtis had not been properly served with a summons and complaint in this lawsuit. I don't think that's what they said. Mr. McRae... First, Mr. McRae does not seriously contest that Mr. Curtis was not served at a proper address under Rule 4J1, such as Mr. Curtis's dwelling, house, or usual place of abode. Rather, he argues that the address at which Mr. Curtis was served is irrelevant because Mr. Curtis's mother was authorized to accept service on her son's behalf. The affidavit accompanying this brief makes clear that Mr. Curtis's mother is not and never was an agent authorized to accept service on Mr. Curtis's behalf. Moreover, the complaint served on Mr. Curtis's mother was not delivered to Mr. Curtis as required by Rule 4J1C. Second, Mr. McRae tries... Rodent, that would be a really expensive pot. I mean, for my beanstalk, so I got a really tall bean plant back there. I don't know if you can see it. It's... Can you guys see that? Right there. It's right here. I planted it in a tea box. Like a Tetley tea box because it needed more space to grow. And so I have another box of tea on the go, so I'm probably what I'm gonna do is I'm gonna move this tea out of the tea box and replant this in the tea box so it's got more stuff. You know what I mean? Whatever. That's not important right now. We're trying to cover this. Stop distracting me. Second, Mr. McRae tries to sidestep proper service by arguing that Mr. Curtis received actual notice of the complaint. Actual notice of a lawsuit, however, does not remedy defective service. As shown below and in Mr. Curtis's opening brief, Mr. Curtis has rebutted the presumption of proper service. As a result, the partial default judgment entered against him is void and must be set aside. Mr. Curtis has rebutted the presumption that service was proper. In his opening brief, Mr. Curtis showed that the partial default judgment entered against him is void under Rule 60b-4 because Mr. Curtis was not properly served with a summons and complaint, ECF number 31 at 4 to 5. Specifically, Mr. McRae attempted to serve Mr. Curtis by certified mail at an old address, ECF number 31 at 4 to 5, ECF number 31.1, paragraph 5 to 6. In his response, Mr. McRae does not dispute that the complaint was mailed to an old address. Instead, Mr. McRae argues that Mr. Curtis's mother was an agent authorized to accept service on Mr. Curtis's behalf, and that Mr. Curtis had actual notice of the lawsuit. As shown below in an affidavit accompanying this brief, Mr. Curtis's mother is not and never was an agent authorized to accept service on her son's behalf. Moreover, actual notice does not cure improper service. Mr. Curtis's mother is not an agent authorized to accept service on Mr. Curtis's behalf. In his response, Mr. McCrae argues that if Mr. Curtis did not live with his mother on August 30th, 2019, service was proper because Mr. Curtis's mother was authorized to accept service on his behalf, ECF number 32 at 3-4. That argument misses the mark. Osman versus Reese, number COA 09950, 2010, WL 1315595, court, whatever, CT app, APR, April, it moved to a date, I recognize April 6, 2010, is instructive on this point. In Osman, the plaintiff served the defendant with a summons and complaint by certified mail at his place of business, ID at *2. A co-worker signed the certified mail slip for the defendant, ID. The defendant received notice of the complaint but never received a copy of the complaint from his co-worker, ID. To rebut the presumption of service, the defendant submitted affidavits stating that the co-worker was not his agent and that the summons and complaint were not delivered to him, ID. The trial court dismissed the plaintiff's complaint for insufficient service of process and plaintiff appealed, ID. So I'm just going to point out here, it does make note of delivered in quotes for some reason, but I don't know, maybe it's in the affidavits that they've added where Kyle's mom hasn't, up to this point, said that she didn't give it to Kyle, so we'll see where it goes. The Court of Appeals affirmed the trial court's conclusion that service was insufficient, ID at *4. The court held that under Rule 4J1C, service by certified mail is achieved, quote, by mailing a copy of the summons and the complaint, addressed to the party to be served and delivering to the addressee, end quote. ID at *2, quoting North Carolina General Statute, paragraph 1A-1, Rule 4J1C. Although the plaintiff produced evidence through the affidavit of service with a return receipt that the summons and the complaint were delivered to the defendant's place of business, addressed to the defendant successfully rebutted the presumption with two affidavits, ID at *3. Here, like in Osman, Mr. McCrae attempted to serve Mr. Curtis by certified mail, and the certified mail slip was signed by someone who is not, quote, an agent authorized by appointment or by law to be served or accepted service of process, end quote, on Mr. Curtis's behalf. North Carolina General Statute, paragraph 1A-1, Rule 4J1B, Exhibit A, Kyle Russell Curtis affidavit, paragraph 4-1. Moreover, like in Osman, a copy of the complaint was not delivered to Mr. Curtis, bracket, in this case until several months after the attempted delivery by certified mail, end bracket. Exhibit A, Kyle Russell Curtis affidavit, paragraph 5. Indeed, here, Mr. Curtis's argument for overcoming the presumption of proper service is even stronger than Osman here because, unlike the defendant in Osman, Mr. Curtis was not even served at a proper address, such as his place of business, dwelling house, or usual place of abode, too. So there's a thing with this place of business bit, which is if Kyle used, which we know he did, because we saw that before a couple of streams ago. We saw Kyle saying, or we saw evidence that Kyle used that address as the non sequitur show address, so therefore it would count as a place of business. In sum, Mr. Curtis has overcome the presumption of proper service by showing that 1, he was served at an old address, 2, that the fact that it's just an old address kills me because, Kyle's not responsible for updating his address at all. He was served at an old address, 2, the certified mail slip was signed by someone who was not Mr. Curtis's authorized agent, and 3, the complaint was not delivered to Mr. Curtis. So this is the 1 and 2 for the affidavits. Mr. Curtis submitted this affidavit in reply to Mr. McCrae's opposition, CEG Artistic SL Inc. versus Lund number 12 CVS 11789 2015 WL 8476587 at asterisk 16 North Carolina Superior Court, December 9th, 2015, allowing a reply affidavit to address points raised in a non-movance response brief. Globe Textile All Inc. versus TDI Worldwide LLC, number 17 CBS 7304 2017 WL 5641185 at asterisk 5 Superior Court, North Carolina Superior Court, November 21st, 2017, same. And then a little 2. In his response, Mr. McCrae alludes to the fact that a defendant can have multiple places at which he or she can be served, ECF number 32 at 4. While that may be true, there is no evidence that Mr. Curtis had multiple dwelling, homes, or places of abode at which service would be proper under Rule 4J1, and there has been no allegation that Mr. Curtis was served at his place of business. Actually, there was, and that's the thing I just talked about, but, whatever. AT2 Production says, I get it if someone doesn't like their mother, but to throw them under the bus in this way is just low. I know, right? Notice is insufficient to overcome defective service. Unless his mother was actually being malicious and didn't give any of this over, but that doesn't seem to be the case here. In his opening brief, Mr. Curtis showed that actual notice of a lawsuit is insufficient to overcome defective service, ECF number 31 at 4 to 5. Mr. McCrae relies on Granville Medical Center versus Tipton, 160 North Carolina App 484, 586, SE2D 791, 2003, and Fender versus Denton, 130 North Carolina App 657, 503, SE2D 707, 1998, to try and sidestep that principle. That reliance is misplaced. In Granville and Fender, the Court of Appeals considered actual notice only in determining that a presumption of proper service had been established. See Granville Medical Center 160 North Carolina App at 492 to 92, 586 SE2D at 796 to 97, Fender 130 North Carolina App at 663, 503 SE2D at 710. Osman is instructive on the role that actual notice plays in determining the sufficiency of service. There, the plaintiff tried to overcome defective service by arguing that the defendant had actual notice of the lawsuit and therefore could not rebut the presumption of service. 2010 WL 1315595 at asterisk 3. In fact, the plaintiff cited Granville and Fender just like Mr. McCrae does in his response, ID ECF number 32 at 5 to 6. The Court of Appeals distilled Granville and Fender as follows, quote, neither Granville nor Fender stands for the position that, as long as the defendant has actual notice improper service on the defendant, would vest the trial court with personal jurisdiction. Osman, 2010, WL 1315595 at asterisk 3. Indeed, quote, a defective service of process may be given the defendant party sufficient and actual notice of the proceeding. Such actual notice does not give the court jurisdiction over the party, end quote. ID quoting Thomas and Howard Co. versus Trimark Catastrophe Services 151 North Carolina App 88 91 564 SE2D 569 572 2002. In sum, if Mr. Curtis had actual notice of the lawsuit, that notice is insufficient to confer jurisdiction over Mr. Curtis. So without jurisdiction, the court can't say you need to do this thing. Mr. McCrae's objection to motion strike should be disregarded. In his response, Mr. McCrae also argues that Mr. Curtis's amended motion to set aside the entry of default and default judgment is procedurally improper on the grounds that business court rules do not contemplate amended motions, ECF number 32 at 1. That argument is misplaced. The fact that business court rules do not reference amended motions does not mean that amended motions are not allowed. To the contrary, there is no rule in the business court rules nor the federal or North Carolina rules of civil procedure that prevents a party from amending her motion before the motion has been ruled on. See e.g. Maint and Serve Inc. versus Lady Deborah Inc. number 5:05 CV 832F-F2 2007 WL 9710804 at *2 EDNC March 21st 2007 bracket overruling arguments about the alleged impropriety of an amended motion to dismiss and electing to consider the amended motion, quote, in the interest of justice, end quote, end bracket. Whew, you know, if Kyle's case wasn't completely flubbernucked, this lawyer probably would have done him really good if he had gotten her right out the gate. If he didn't, you know, lie about having an attorney and then lie to his attorney. You know, what do I know? I'm just a goblin. In any event, the business court rules do address the form in which motions must be presented. Business Court Rule 7.2 makes clear that, quote, all motions must be accompanied by a brief, end quote, and, quote, must be set out in a separate document, end quote, BCR 7.2. Mr. McRae's attempt to include a motion to strike in his response to Mr. Curtis's motion to set aside violates Rule 7.2 and should be summarily denied. CID bracket stating that the court may summarily deny a motion that is unaccompanied by a brief, end bracket. Conclusion, as Mr. Curtis noted in his opening brief, the provisions for setting aside default judgment are to be liberally construed, quote, liberally construed as to give litigants an opportunity to have a case disposed of on the merits, end quote. Estate of Teal versus Darby, 129, North Carolina App 604, 607, 500, SE2D, 759, 762, and 1998. Whew. Thus, quote, any doubt should be resolved in favor of setting aside an entry of default, end quote. John Henry Spainhour and Sons Grading Co. versus Carolina E.E. Homes Inc. 109 NC App 174, 183, 426, SE2D 728, 733, 1993, quoting Beard versus Pembar 68, North Carolina Apps 52, 56, 313, SE2D 853, 855 in 1984. Letty says, and lie about having an official CPA and then turning in his garbage books, Lamal. Oh, God, those books. Oh, those books. Those books are just embarrassing for whoever put those together. I can't imagine if that person runs any other business. If they did, they probably ran it in the ground with books like that. Or, you know, their books of that business might not be, you know, all kosher. For the reasons stated in this brief and in Mr. Curtis's opening brief, defendant Kyle Russell Curtis respectfully moves the court to set aside the entry of default under North Carolina Rule of Civil Procedure Rule 55D, to set aside the partial default judgment under North Carolina Rule of Civil Procedure Rule 60B, and grant all other relief that it deems necessarily this 24th day of August 2002. So, one thing that is nice about Kyle actually getting a lawyer, one thing that is nice about Kyle actually finally getting a lawyer is that, you know, things actually started proceeding at a relatively quick rate at this point. Then we've got the certificate of compliance, and then we've also got the certificate of service. Huzzah! So that was 33. So if anybody's curious as to what we're on out of 57 so far, I think we're still at 57. Yeah, we're still at 57. And then we have the Exhibit A, so this is the exhibit that they were referencing in this brief. So Kyle gave us another affidavit. Exhibit A, affidavit. Oh, this is the stuff we read already. They didn't actually submit anything new that says that Kyle didn't actually receive the paperwork, just that, like, this is the stuff we already read. So this is just the Kyle's affidavit saying, nah, I didn't live there though. My mom signed for it. I think we read all this. I'll read it really quickly. State of North Carolina, Guilford County, Stephen McCrae plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division, 19 CVS 8163. Affidavit of Kyle Curtis. I, Kyle Curtis, being duly sworn, states as follows. My name is Kyle Russell Curtis. I'm over the age of 18 now and competent to provide this affidavit. On July 28, 2020, I executed an affidavit showing that I have never been served with the compliance in this matter. Oh no, this is new. As I stated in my July 28th affidavit, the complaint filed against me was mailed to my mother's address at 1532 Providence Church Road, Pleasant Garden, North Carolina 27313 in August of 2019. My mother, Susan Curtis, signed the certified mail slip attached to the affidavit of service on August 30th, 2019. I did not reside at 1532 Providence Church Road, Pleasant Garden, North Carolina 27313 on August 30th, 2019. Rather, I resided at 2543 Anna Garrison Road, Charlotte, North Carolina 28263, which has been my address since July 16th, 2019. I understand that Mr. McCrae is now claiming that my mother signed a certified mail slip as, quote, an agent authorized by appointment or by law to be served or accepted a service of process, end quote, on my behalf. That is not true. My mother is and was in no way my agent, nor is or was she authorized to accept service of a lawsuit on my behalf. 5. I did not receive the notice of this lawsuit from my mother. Rather, I received a YouTube link to a stream in which plaintiff Stephen McCrae, as discussing the lawsuit. When I first obtained a copy of the complaint several months later, I filed a motion to set aside the default judgment that had been entered against me. This, the 24th day of August 2020, Kyle Curtis, sworn 24th of August, blah, 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 notary. So, there's a couple things in this that I think are kind of interesting that we know are not necessarily the case. He received a YouTube link to a stream in which the plaintiff, Stephen McCrae, was discussing the lawsuit. Okay. When I first obtained a copy of the complaint several months later, I filed a motion to set aside the default judgment. The thing is that's not the issue I take with this is that that's not the first thing he filed. The first thing he filed was compliance, non-compliance. Then he filed the default judgment to set aside stuff, to say he didn't live there. Will I start an Amazon wish list for my tomato plant? I don't know. Does it need anything? I guess I could put pots on there. Rodent, no last name for 5. Was Kyle's lawyers legalzoom.com? Question mark. Also, secondhand store, cheap stock pot, drill, drainage hole, add soil. Good point. Yeah, I might be able to go to a secondhand store, when lockdown lightens up again. Right now we're on full lockdown again. Draft myself, 5. Here's for being a masochist goblin for subjecting yourself to this marathon reading this stuff. Thank you. I will boop Puck when he comes back. He just went into the other room. So when he comes back, he will get his boops. Rodent, no last name, says, I'm Kyle Curtis. I am over the age of 18, and I am a rabid weasel in a burlap bag with bad diarrhea. Oh, that's so upsetting. That's animal abuse. Hey guys, remember, music is the only language you can't lie in. Oh, dear Lord. Number 34. Notice of hearing. Hooray! Finally got a hearing a year later. Number 34. State of North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division, 19 CVS 8163. Notice of hearing. 1. Take notice that the court will hold a hearing on this matter on defendant Kyle Curtis's amended motion to set aside entry of default and partial default judgment, the motion. ECF number 30. Ooh, the motion. That sounds ominous. On Friday, September 11th, 2020, at 10 a.m. via WebEx video conference. Instructions for joining the video conference will be provided separately by email to all counsel of record. This is the first day of September 2020. Yay! September, a year and a month. God damn. I mean, considering service was on August 30th, was like confirmed on August 30th, then yeah, that's pretty well a year exactly. Affidavit. So let me just look real quick. Okay, so here's POTS. We're going to go to 35, 36, and 37, and then we'll then that's where we'll stop at before 38, because that's when things start getting spicy again. Number 35, affidavit. So North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant, in the General Court of Justice, Superior Court Division, 19 CVS 8163. Supplemental affidavit of Stephen McCrae in opposition to defendant's amended motion to set aside. I, Stephen McCrae, duly sworn, state as follows. I am over the age of 18 and am competent to make this affidavit. I previously submitted an affidavit in support of my opposition to defendant's motion to set aside default judgment ECF number 22. In support of his reply, Mr. Curtis has submitted another affidavit, ECF number 33.1. This affidavit responds directly to Mr. Curtis' allegations in his new affidavit. Basically, Kyle's affidavits keeps giving Steve more of a reason to keep responding to him, which is, in support of his reply, Mr. Curtis has submitted blah, 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 blah. In my previous affidavit, I explained that the address that my attorney used to serve Mr. Curtis is the address that Mr. Curtis always used in my dealings with him, ECF number 22 at paragraph 3 to 6. Mr. Curtis has not disputed this in any of his affidavits. In my previous affidavit, I also provided evidence of instances where Mr. Curtis represented in public forums that he had been served with the complaint, that he understood the allegations in the complaint, and that he failed to appear in the case, even after telling people he had hired an attorney to appear on his behalf, ID paragraph 7. Okay, so this is essentially referring to the original papers that I was served, that he was appearing saying that he was ready to rumble, and then that he didn't show up, and then that he had an attorney the entire time but didn't actually have an attorney. Mr. Curtis has not disputed these instances in any of his affidavits. Mr. Curtis stated that his mother, Susan Curtis, was not authorized to accept service on his behalf, ID at paragraph 4. He does not dispute that she did sign for it on his behalf. Ms. Curtis stated in her affidavit that she signed for the certified mail address to Mr. Curtis, ECF number 32.2 at paragraph 3. Mr. Curtis further states that he, quote, did not receive notice of the lawsuit from his mother, and he first obtained a copy of the complaint several months later, ECF number 31.1 at paragraph 5. This statement is contradicted by multiple statements made by Mr. Curtis in public forums. Papers that I was served. The complaint was served on August 30th, 2019, ECF number 7. A few weeks later, on September 23rd, 2019, Mr. Curtis participated in a group chat session on Discord, which is an online text, voice, and video chat service that allows users to communicate online. This discussion was open to the public and took place well before the deadline for Mr. Curtis to respond had passed. A true and accurate recorded copy of the session can be found here. I'm not going to it. We're not listening through all this. I don't want to know. I'm not doing it. At 1951, anybody can go and look at this. Anybody can go and find this if you'd like. At 1951, the interviewer stated that Mr. Curtis, quote, as I understand it, you were served papers on the suit from Steve against you, and I'm curious if you have legal representation, or if you either have or are intending to respond to it, question. Mr. Curtis did not deny that he had received the complaint. Instead, he said, quote, of course I responded to the lawsuit. Not responding would be a dumb decision. So that's going to be taking place in a couple of weeks. There is a ... I'm not going to speak of it anymore aside from that, but yet it will be happening. We are set to rumble, end quote. Later in the same discussion, at about 44 minutes 20 seconds, Mr. Curtis appears to contradict his contentions concerning his residence. When he was asked if he had moved, Mr. Curtis responded, quote, no, I spent ... me and my boyfriend live in different cities, so I guess if I'm gone from home more than twice a week, I moved, question mark. So he called his mother's house home, saying that he hadn't moved because he would spend, time with his... Oh, no. On October 6, 2019, 3 days after the entry of default was filed, Mr. Curtis participated in another Discord conversation. This conversation was referenced in my previous affidavit, ECF number 22 at paragraph 7, and a true and accurate recording can be found at this link. How do you fuck this up? It's because he didn't plan his lie ahead of time. And it's almost like he came up with that idea out of nowhere, out of his ass. That definitely, I'm sure nobody suggested to him at all. I'm sure nobody else had anything to do with that. Ugh. The link is there, so if anybody wanted to, like, type it up themselves, it's there. But again, you can go to this if you want to go find it. At 4 minutes and 30 seconds in the recording, discussing his failure to respond, Mr. Curtis states, quote, "I missed a filing deadline because of something going on with on my side, not Steve's, so that was my fault, but there, ... it's not going to be appealed." Oh, it's going to be appealed. Who knows what an appeal is. At 15 minutes and 57, Mr. Curtis states, quote, "What I did was, in the original papers that I was served, there's an attachment part I had to fill out where I, messed up on the procedural issue with that, and then filed that on Friday with the clerk of the court," end quote. Mr. Curtis, of course, had not filed anything with the court, or with the clerk. God's Auditor, Part B, there is a damning part, not the papers that I was served. The next part of the attachment, they were only included with the certified mail. Good point. Good point, God's Auditor. Highlight that shit. Finally, on January 20th, 2020, Mr. Curtis participated in it. So that's the, you're talking about there's an attachment part that I had to fill out where he messed up, supposedly. So that's the part that God's Auditor is referring to, I think, if I'm not mistaken. 10. Finally, on January 20th, 2020, Mr. Curtis participated in a YouTube interview where he discussed the case in some detail. The video for the interview is available online and can be found here. Bam! What video is this? I don't know which one this is. Oh, it's gonna... I should have opened it in a new tab. God damn it. Okay, well, whatever. What is this? Oh. Ooh, that like to dislike ratio is spicy. I like that. 22nd January. Kyle Curtis, owner of the Non Sequitur show. This will straighten out a lot of the story. Thanks. Thanks, bud. Oh, it took me all the way back. No. Alright, that's fine. I'll go back to get it. This is what I get for pressing the wrong button. I just wanted to know which interview it was. He's done so many. Flip this around. So now you guys can see that I didn't actually pull this out of my ass. I actually went to the fucking website. Notice of hearing affidavit. This one. Here we go. On 35. Whoop. God's Auditor says, yeah, those are not included with the documents on the court website. Those would arrive with certified mail, meaning Mama gave him the certified mail. Exploratory Minds Project says, I imagine Kyle appeal something like, it's not fair because I didn't have enough due notice. I was busy. Yeah, I mean, yeah. Okay, YouTube, here we go. At 1 hour, 10 minutes, and 44 seconds of the interview, Mr. Curtis states that he, quote, made a mistake and didn't handle things the right way. And I mean, it's been shown now, but I didn't show up to court and I lied about having an attorney. That was continuing the case, ellipses, end quote. At 1 hour, 14 minutes, and 40 seconds, Mr. Curtis states about the court case that he, quote, didn't want to deal with anything that was going on, and that's why he didn't show up, end quote. At 1 hour, 20 minutes, and 24 seconds, Mr. Curtis states, quote, if I could go back, I would have absolutely not just, blown it away and shown up like I was supposed to, but it's still the situation even though I didn't show up and there was a default judgment declared, but declared he's not been able to prove his side of the damages, end quote. Mr. Curtis does not at any point in the interview complain that he did not receive a copy of the complaint until several months later, as he states in his latest affidavit, ECF number 331 at paragraph 5. Pursuant to Emergency Directive 5, I affirm under penalties of perjury that the foregoing representations are true. This is the 3rd day of September 2020, Steve. Do you think people like Kyle better because his signature looks better than Steve's does? Like, look at that shit. What garbage fucking... Did you do this with a mouse? Did he sign this? This looks like he signed it with a mouse. Steve, please. Why? God damn it. Well, I'm picking on him, okay. Certificate of service, and boom, next docket, 36, motion to strike. This is Kyle's lawyer. So, State of North Carolina, Guilford County, Stephen McRae, plaintiff, versus Kyle Russell Curtis, defendant, in the General Court of Justice, Superior Court Division 19, CVS 8163. Motion to strike the supplemental affidavit of Stephen McRae, ECF number 35. Expedited response requested. Woo! Pursuant to Business Court Rule 7.5, North Carolina Rule of Civil Procedure 12F, the North Carolina Rules of Evidence 901 and 902, defendant Kyle Russell Curtis respectfully moves the court for an order of striking the supplemental affidavit of Stephen McRae filed on September 3rd, 2020. So they're trying to, they don't want Steve's affidavit. They want it stricken from the record. ECF number 35. The basis for this motion are detailed in the accompanying brief. In light of the hearing on Mr. Curtis's amended motion to set aside, scheduled for the morning of September 11th, Mr. Curtis requests that the court order Mr. McRae to file any response to this motion to strike by 9 p.m. on Wednesday, September 9th. Pursuant to Business Court Rule 7.3, the undersigned counsel consulted with counsel for Mr. McRae about this motion. Counsel for Mr. McRae noted his position as follows and asked that it be included in this motion. Plaintiff does not consent to defendant's motion or request for expedited briefing. The reason plaintiff did not file a motion to strike defendant's improper and late filed affidavit is because plaintiff wants this matter to be reached rather than hold additional rounds of briefing, which only serve to further delay. The plaintiff has been awarded 1. Plaintiff intends to respond to the motion to strike 6th day of September 2020. Mr. Curtis strongly disagrees with counsel's characterizations of Mr. Curtis's affidavit and its relevance to this motion to strike. Certificate of service. So this is essentially Steve's lawyer had an opportunity to strike this affidavit, one of the affidavits up here. They didn't, and the reasoning posted here is because they want to resolve the issue. Then Steve responded to Kyle's affidavit, this one here. Oh, sorry, this one up here. That's why it said at the beginning, hey, this is my response to this. He added these things in, so I'm responding to these specific things. So, brief support. So this is their reasoning for their motion to strike. State of North Carolina, Guilford County, Stephen McRae, plaintiff versus Kyle Russell Curtis, defendant, in the General Court of Justice, Superior Court Division 19, CVS 8163. Brief in support of motion to strike this supplemental affidavit of Stephen McRae, ECF number 35. Expedited response requested. Pursuant to BCR 7.2, defendant Kyle Russell Curtis submits this brief in support of his motion to strike the supplemental affidavit of Stephen McRae filed on September 3rd, 2020, ECF number 35. Who did I see? Sean. My cursive is pretty bad too, Chesh. Okay, listen. There's a difference between knowing how to write regularly in cursive and knowing how to sign your name. In my humble opinion. Puck! You have boops that you need. Come get boops. A boop, boop, boop. He got boops. There's his boops. Oh boy. I'll give you a cheesy later. He likes cheesy poofs. Relevant background. Defendant Kyle Curtis has moved to set aside the entry of default and partial default judgment entered against him in this case, ECF NOS 917. Mr. Curtis filed his amended motion to set aside on July 28, 2020, ECF number 30. Mr. McRae filed a response on August 11, 2020, ECF number 32, and Mr. Curtis filed a reply on August 24, 2020, ECF number 33. After the close of briefing, the court noticed a hearing on the amended motion to set aside for September 11th, ECF number 34. On September 3rd, Mr. McRae filed an affidavit, which he styled as a supplemental affidavit of Stephen McRae in opposition to defendant's amended motion to set aside, ECF number 35. Mr. Curtis moved to strike that affidavit. Argument. The supplemental affidavit should be struck. As explained below, Mr. McRae's supplemental affidavit should be struck because 1, it's an improper surreply for which Mr. McRae did not seek leave of court, 2, contains inadmissible evidence, and 3, does not address new arguments raised in Mr. Curtis's reply brief. Apparently, Kyle saying that he was served is inadmissible. Okay. The supplemental affidavit is this poor lawyer, Kyle's poor lawyer. The supplemental affidavit is an improper surreply for which Mr. McRae did not seek leave of counsel. Mr. McRae's supplemental affidavit is an improper attempt to file a surreply without leave of court. Under the business court rules, proper motion practice consists of only a motion and accompanied brief, a response, and a reply. CBCR 7.5, 7.6, 7.7. Quote, all materials, including affidavits on which a motion or brief relies, must be filed with the motion of brief. B. Business Court Rule 7.5, emphasis added. As the court has previously explained, surreply briefs are not permitted by this court's rule and generally are disfavored. Worley versus Moore, number 15, CVS 1316, 2016, WL 845484 at asterisk 2, North Carolina Super Court, July 14th, 2016, denying a motion for leave to file a surreply. For this reason, the court, as well as federal courts in the state, routinely deny motions for leave to file a surreply and strike surreplies filed without leave of court. See E.G. Wharton versus Huttaf, number 10, CVS 4082, 2013, WL 5872961 at asterisk 15, North Carolina Superior Court, October 29th, 2013, D. Paulo versus Potter, 733, F. Sup. 2D 666, 670, MDNC 2010, bracket, noting that, quote, parties do not have a right to file a surreply, end quote, end bracket, Spivey versus Wright, RSCH triangle, Regal Pub Transp off. I feel like I'm speaking another language. Number 5:14 CV 44 FL 2015 WL 5513320 at asterisk 1 EDNC August 10th 2015, striking a surreply that was filed without leave of court, adopted 2015 WL 5455919 EDNC September 16th 2015 aft 633 F appendix 830 AppX, I think that's appendix 839 4th SIR 2016 Ivanica Nikovala versus E. Carolina UV, number 4:08 CV 209BR 2011 WL 2462468 at asterisk 5 to 6 EDNC June 17th 2011, disregarding an improperly filed surreply. Here, Mr. McRae filed the equivalent of a surreply without even attempting to seek to leave court. It's almost like it might not be considered a surreply. I guess we'll have to see. To be sure, the supplemental affidavit supports to respond directly to Mr. Curtis's allegations in his new affidavit, end quote. ECF number 35, paragraph 3. The supplemental affidavit is improper under the business court rules and accordingly should be struck from the record. The supplemental affidavit contains otherwise inadmissible evidence. In addition to the defiances noted above, Mr. McRae's supplemental affidavit should be struck because it relies on unauthenticated inadmissible evidence. First, the affidavit relies on recordings of purported Discord group chat sessions located on a Google Drive, see ECF number 35, paragraph 8 to 9. Mr. McRae, however, cannot authenticate the recordings simply by filing an affidavit. Rather, he would need evidence from a witness who observed the recordings, see North Carolina General Statute, paragraph 8C-1, Rule 901B1. Here, Mr. McRae has offered no evidence connecting the recordings to Mr. Curtis, except his voice, I guess, or even Mr. Curtis's IP address, which he must do to use the recordings as substantive evidence. CEG State v. Little 253, North Carolina App 159, 169, 799, SE2D 427, 433, 2017. Without proper authentication, Without proper authentication, there is no way to know if the recordings have been edited, among other things. Second, the affidavit relies on a YouTube video, ECF number 35, paragraph 10. Didn't Kyle submit a YouTube video that was obviously chopped to hell as evidence that Steve submitted it to the wrong address purposefully? Yeah, hold the phone. Hold on. Wait a minute. Like the Discord recordings, Mr. McRae has failed to authenticate the video. How do you authenticate a YouTube video? I'm curious. I'm just, if you guys have any idea of how to do that, you guys let me know. Unlike the federal rules of evidence, under North Carolina's evidentiary rule, YouTube videos are not self-authenticating. Compare FR Evid to Smitty, thanks for reading all the numbers. It's important. Listen, I'm doing this so people who can't read will be able to look up the stuff, because we know that there's a lot of people that are talking about this who don't know how to read. I'm trying to help. Don't pick on me. 902.11 with North Carolina General Statute paragraph 8C-1 Rule 902 containing no such corollary provisions. Even under the federal rule, however, authentication of a YouTube video requires that the proponent provide certification that satisfies the requirements of the business records hearsay exception. See federal rule, I think this is federal rule evidence. 8036 United States versus Hassan 742 F3D 104 133 4th Sir 2014. For example, one federal court found that a YouTube video had not been authenticated because the plaintiffs had, quote, not preferred the certificate of YouTube's custodian or other qualified person verifying that the page had been maintained as a business record in the course of regular conducted business activities. But the YouTube channel is the business in this case. I know that's not really what they're talking about, but this just seems like a bizarre argument to me. Randazza versus Cox, number 2:12 CV 2040 JADPAL 2014 WL 1407378 at *4 DNEB April 10th 2014. Mr. McRae has not attempted to authenticate the YouTube video that he relies on as substantive evidence in this affidavit. These portions of Mr. McRae's supplemental affidavit are inadmissible and should be struck. 1. To the extent that Mr. McRae attempts to rely on Discord recordings or YouTube video sites in earlier affidavits, those affidavits should be disregarded on the same grounds. So they're saying anytime Steve has mentioned anything about these recordings or that any of this, that it all should be struck. The supplemental affidavit does not address new arguments made by Mr. Curtis's reply and brief. Finally, in the event that Mr. McRae requests leave to file his supplemental affidavit as a late surreply, that request should be denied because the affidavit does not address arguments newly raised by Mr. Curtis's reply. See Del Paulo 733 F Sup 2D at 670. In his affidavit, Mr. McRae states that the Discord recordings and YouTube video contradict Mr. Curtis's sworn testimony that he did, quote, did not receive notice of this lawsuit from his mother, end quote, and that he first obtained a copy of the complaint several months later, ECF number 35, paragraph 7, quoting ECF number 33.1, paragraph 5. Mr. Curtis's affidavit, however, made clear that he learned of the lawsuit from a YouTube stream in which Mr. McRae was discussing a lawsuit. He simply did not receive a copy of the complaint until several months later. ECF number 33.1, paragraph 5. Thus, even if Mr. McRae had properly authenticated the Discord recordings and YouTube video, which he has not, the contents of the affidavit, which focus on Mr. Curtis's knowledge of the lawsuit, would in no way contradict any argument made in Mr. Curtis's reply brief. After all, actual notice of the lawsuit is insufficient to overcome defective service. See ECF number 33 at 5 to 6. Accordingly, there is no basis on which to allow Mr. McRae to file a surreply. Mr. McRae should respond to this motion before the hearing on Mr. Curtis's motion to set aside. The court has scheduled a hearing on Mr. Curtis's amended motion for the morning of Friday, September 11th. Mr. Curtis' motion to strike attacks the admissibility of materials that Mr. McRae has submitted in opposition to the motion to set aside. Accordingly, Mr. McRae should respond to the motion to strike before the hearing. Mr. Curtis requests that the court require Mr. McRae to file and serve his response to Mr. Curtis's motion to strike before Wednesday, September 9th at 9 p.m. That makes sense. They're just saying, like, hey, listen, if you're going to... We're saying that you should strike, that this should be struck. If you're going to respond to this, we want you to respond by this day instead of the necessary allotted time because there is a motion, there is notice for a hearing. So we just want that ahead of time. This, totally reasonable, makes complete sense. Conclusion. For the reasons stated in this brief, supplemental affidavit of Stephen McRae in opposition to defendant's amended motion to set aside should be struck and should not be considered by the court in ruling on Mr. Curtis's amended motion to set aside this 6th day of September 2020. I mean, to be fair, they kind of have to get this struck because this is a really, really bad... most of that destroys any of Kyle's arguments that he was making. Certificate of compliance, and then, of course, the certificate of service. So, 37. Brief in support, except summary judgment, blah, 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 blah. No, this is the thing I just read. All right. Yeah, so this was their defense in saying that it should be struck. Then the court has their... after this, so you'll notice that this is 09/06/2020, and then we've got 09/09/2020. So this right here is... 2 affidavits, one from Benjamin Potts, one from Megan Joyce, and this is the plaintiff's response to the motion to strike. So, they asked for everything by September 9th. This is what they got on September 9th. And we will check that out next time. I really like this plant. I'm going to put this out outside for now, though. So, there's a lot we covered today. For every one of these, there's kind of a lot that goes on. So, if anybody's interested, here's the link. If you need to find this yourself, go just Google North Carolina Business Court. It will be under public access, and then you can just... What I do is I just search for the judge name, hit go, and then I just scroll down to McRae versus Curtis, but there's the ECF number. Everything is right there if you need to find it yourself. The links to the Google Drives and everything is all public, so if you want to go check them out, you can go and check those out and download them or whatever. Go for it. Leave me any comments or questions that you have. I'll see what I can cover. But as for my announcement for today, so there was a bunch of fun that happened last night. It turns out Kyle decided that he wanted to poke his wee little head out. He decided that he, Astronomy Live is in the chat now, yeah, oh my god, that video you had me transcribe, multiple layers of fuckery, pretending there is no evidence, he forged documents. Yes, Kyle decided he wanted to poke his head out, and make some claims and make a bit of an appearance. So, on Friday night, we will have a stream taking a look at what Kyle had to say. There will be 2 people joining me and a 3rd secret guest. So Golden Unicorn Mania will be joining me on Friday. Dottie Morgan will be joining me on Friday, and mystery guest number 3. I'll let you guys guess who that may or may not be. You guys let me know who you think it might be, and I'm excited. This is gonna be fun. So I hope you guys are ready for the circus of Trigglypuff clowns to begin. Like, subscribe, hit the bell to make sure you get notified for that. And I will see you guys, same bat time, place. Same bat time, same bat place tomorrow, and we will cover Steve's lawyer's response to the defense. And we haven't had it that time of the month in a little while. I've been busy with this stuff. We'll get to see Ben. So everybody give your support to Ben. Ben is amazing. Ben has always been amazing. Ben has been amazing through this entire thing. Essentially, I guess he found out about something, because I find it interesting considering Kyle's the one who brought Ben up to sign the lease, but for some reason, Ben's affidavit is being filed by Steve's lawyer. I wonder why. We'll find out next time. See you guys tomorrow. Again, same bat time, same bat place. Become a member, subscribe. Become a Patreon if you're interested. Stuff's always going on in Discord over there if you decide to become a member, and you get Trigglypuffy stuff. Yay! All right, we'll see you guys tomorrow, and maybe I'll give a little bit more information about what's going on Friday by then. Kiss, kiss. See you guys next time. Bye.